that's what we are, that's what we do. So the team of the help desk is about 10 persons working there and in different premises. And as I said, our main topic and the hot topic is, of course, you have a question?
Yes, sorry.
You're always free to ask questions.
Yeah, sorry, of course. My question is, you mentioned Horizon 20, I mean, the IPRs or IP, do they have to be related to Horizon 20? For example, if someone, will that need to be as a part of Horizon 20 to seek your support? Or can it be, for example, if you've got IPR patents which are filed from other projects, can we seek support from you?
You could, but you should address to the aggregators either in the framework of a European finance program like Horizon 20 or with an international dimension. So we cannot answer a question, for example, I'm working in an institution and I have a question to patent. Then we would have to, let's say, to signpost you to your local technology transfer office or to the national patent offices. As we are financed by the European Commission, that's more or less the regulatory framework we work in. So it should, if you have an international dimension, so if something developed and I would like to open into a cooperation with a partner in the Netherlands or outside your country, yes, you can. That's kind of a precondition. Other questions? Fine. Yeah, as I told you, Horizon 2020, of course, but we are still also working a couple of FP7 projects. So, which are in the implementation phase. And of course, we see now that we got more and more questions related, of course, to Horizon 2020. And I think people understood that they have to address better, more precisely, innovation and IP aspects when they write proposals. And of course, this is something which also addresses to us. And the idea behind the story is that there was an assessment, of course, of the results of FP7, and you see some of the, let's say, main findings that, let's say, for example, less than 50% of the industrial partners are using public funds for strategic innovation. So we always talk about strategic use of IP, the strategic use. So it's not just by chance that we say, okay, I'm entering an Horizon 2020 proposal because I see the chance to develop something which I'm going to exploit later for further research or for businesses. In particular, this relates also to the SMEs, and of course we see the SMEs that they don't have legal units or business units which help them, let's say, dealing with innovation as it is the case for larger industrial partners. And we see here also that the results are not exploited as they could be because they are not designed in a way that they should focus on exploitation, innovation. And I'm very happy that Eugene Sweeney is with us today as a trainer, and he's also giving some insights from the evaluation of the proposals now in Horizon 2020, that some of them do not address innovation properly in a way, and we would expect that we get some recommendations and some ideas how to do it better in the future. So Horizon 2020 should, let's say, overcome that problem to be more pretty much driven by innovation, by a commercial view or by innovation aspects. And it's addressing, let's say, the full value chain of innovation. So we will find in Horizon 2020, of course, a number of elements dealing with basic research, dealing with scientific excellence, like the ERC, like the Marie Curie schemes. But of course, we see also more and more elements focusing on applied research, as we have it here at Brooks, or even business development. And I think this is a big shift of Horizon 2020 with regard to FP7, that there are more opportunities. It does not mean that there's no opportunity for basic research. There is no opportunity for academics. There are more opportunity also to include more market-driven activities, like validation, prototyping, demonstration or upscaling of lab facilities. A number of research organizations dealing with applied research to be involved in Horizon 2020 and to enter with that kind of activities. So of course, IP is an issue whenever you go closer to market conditions, and So what do we find then in the, let's say, rules for participation or in the general conditions to participate in Horizon 2020 with regard to IP? It becomes a more regarding the impact and the feasibility of the proposal, and it's more addressed also in the evaluation of the proposals. So in a number of core topics, it's a must to have a good outlined IP and exploitation strategy. Should help you also to address this issue more properly. And of course, it's not only just to be successful, but of course to avoid conflicts. Just another example. So if you not consider IP properly by setting up your proposal, then you might run into some problems because you are infringe IP of others, or you have IP of third parties involved in the project, and then at one moment in your project you run into problems. So there are many reasons to consider IP as an important element, not only just during the project implementation, but in particular when you design the project and when you plan and write the proposal. The expectations on IP in Horizon 2020 of course differs a lot regarding the specific instrument, regarding let's say the market relevance of your project, but also the TRL, and I'm sure we'll come to that as well, so the technology readiness level, and some of the topics you will find a clear indication on that. So if you have a lower TRL, of course IP might not be as important as it is in those projects in which you have a high technology readiness level, you know, starting from 1 to 9, and of course if you have a high technology readiness level, which means about 6, 7, 8, which you will find in some industrial driven programs, then of course innovation and IP is a main element, and you will never be successful with your proposal if you do not address it in the right way. Of course, the more partners you have from the industry, or your more SMEs you have among the academic consortium, of course IP might become more important. The financing instrument, you know, there are innovation and research actions, and there are innovation actions, and of course again they are more driven by innovation. If you apply for a project in an innovation action, then of course there are higher expectations on how to address IP as, for example, in the research and innovation action. The size of consortium, the more partner you have, the more IP issues might occur, and of course the stage of proposal. I mean, you see that now, in particular with regard to full proposals, people have a couple of questions and are more dedicated to IP, of course, than it is in the first stage. And that brings me to the fact that, of course, in order to address it properly, you have to have the right strategy. That's what we're going to talk about later. But you have to know also about the rules. So there are standard rules, and there is good news because they are more or less following what you know from FP7. So it's not there are really big changes. However, you should know about small changes, and you should know about the overall framework to address it. And we've seen that now in the first call for proposals, that many proposal writers simply referred to the rules. I know about the rules, I'm an IP expert, I know about the strategy because I know how to draft a consortium agreement. That's nice, that's something which you can point out, and that you know about the IP setting, but of course you are expected to design a strategy based on the rules and based on the formal aspects of using IP. So that's why we start with that one. Sorry.
Excuse me, will these presentations be circulated on email afterwards?
It will be made available via...
Good.
You can even download them afterwards on the website, but you didn't want to distribute them before.
No.
Yeah.
Yeah, you get access to it. Yeah, and there is, of course, there is the first, let's say, the umbrella, which is the grant agreement to be signed between the European Commission and the consortium. And this is also given as an annotated grant agreement, so it's a standard agreement, and you can find that also on the participant portal, and it's continuously updated, and what you will find there is quite a big document with more than 300 pages, which is not always easy to read, it's not always easy to understand, but there are about, let's say, 20 pages which are addressing IP issues. What you see there is that not only, let's say, the legal terms of the grant agreement, which is the core text, but also annotations. So the European Commission tried to explain what does it mean, what are the terms, and what is the meaning of the terms, and to give examples of how the terms could be applied in Horizon 2020 projects. So it's worth to have a look at, because it's not only written for legal experts, but with a number of annotations, with a number of examples also for the scientists and the SMEs taking part in Horizon 2020. And you will find it on the participant portal. In addition to the grant agreement, which is a legal standard document, there is nothing to be negotiated, nothing to be decided from your side, so it's given by the European Commission. There is the consortium agreement. The consortium agreement is an additional agreement. So it's not replacing, it's an additional agreement to the grant agreement. It is ruling the internal scheme of the project participants, of the beneficiaries of a project. It is a legal document, it is mandatory, so it's not something you might have, you are asked to have it, and you are asked to have it before you start with your project, which is a big issue in Horizon 2020. Because you know, due to the pressure of the European Parliament, there is a reduction of the time to grant, which is 8 months from the evaluation, from the results. So it means normally you have about 3 months for the grant preparation, which means 3 months to finalize or to negotiate it. What we learned is that, in particular in the first year or the first 2 years of Horizon 2020, the Commission will not be too strict on that. So if you finalize your consortium agreement, let's say in the very first 1 to 3rd months of the project, it's still fine. But of course, you are expected to have at least, let's say, a draft available when you start with your project. And the earlier you start with negotiating the consortium agreements, the better it is. And you might know from your own experience that IP issues are normally a big issue and could cause many delays in drafting a consortium agreement. In particular, if you work with larger companies or in projects which are quite sensitive on IP. So the legal basis for the consortium agreement is still the grant agreement. Of course, it cannot be contradictory to the grant agreement. And there are also good news that you do not have to start from the scratch. So there is a template available, and there are different templates available. And the one which is going to be the most useful for you is the DESCA model. And you see their website, you get that. And this is a standard, a template consortium agreement, which has been developed in particular from IP experts coming from academia and research centers. So that should apply to your needs. But for specific programs, like for example for manufacturing, car manufacturing, they have different consortium agreements, which are pretty much all ICT, electronics, mobile communication. So they have, or pharmaceutical companies. So they have specific consortium agreement models which I would say serve more the needs of the industry. So you will see there are some changes and some modifications which are more in favor of the needs of the industry as it is in the DESCA model. So the DESCA model is pretty much in favor of the universities and the research centers. For example, when it comes to under which conditions you can provide licenses, or when it comes to the period of time in which people can ask for information. So that those are the kind of changes. But of course, for all of them, it's important that the grant agreement is the binding agreement. But it's usually to work with consortium agreement models which are not based on the DESCA model. If inside the DESCA model you have different options. It's not just to say for any article we have only one option. In some articles also you can opt which is the one which is the most useful for. And if you are a university or an academic or a research center which is entering a couple of projects in the future, which and we're very glad for you, then it might be good to have a discussion with your legal department at the very beginning now of Horizon 2020, so that you have a standard model for your institution, that you know whenever our scientists are entering into a project, this is the DESCA option model which we prefer, but then of course it's subject to negotiations with your partners. So what are the rules? You can find them all on the participant portal. You see here, there are the rules for participation, grant agreement, and the online manual, which is not ready yet. It's still under construction, but it's most probably that we will put then our IP guide there. If you work with the agreements, consortium agreements, grant agreements in Horizon 2020, you have to get acquainted with a couple of terms, which are very briefly introduced to you. If you have been working in FP7 before, you will know them, more or less. So of course, you will be asked to identify the background, your IP, your knowledge, your IP assets, which you bring into the project. If you are selected in the evaluation procedure, you are selected because you have the track record, you have some experiences, you have reputation. So it means you should have done research before, for sure. And it means that you have background available in your institution, in your lab, which you bring or you bring not to the project. And it's up to you to say what is the scope of knowledge. And the scope, it could be registered knowledge or non-registered, it could be patents, or simply knowledge about procedures, knowledge about methodologies, which you bring into the project. You can exclude it. For example, if you work in a specific engineering issue with a Formula One company, then maybe you are not free to bring that knowledge to Horizon 2020 project, and you have to exclude it. Why it's important to exclude it? Because if you do not exclude it, and another consortium partners can justify that he needs your knowledge to perform his or her task in the project, or needs the knowledge to exploit the own results later, then you have to provide access to that knowledge. So that's the rule of collaborative research. So if you say, I have a couple of, let's say, exclusive research contracts which are closely to the topic and closely to the technology, with I'm entering that Horizon 2020 proposal, then it might be very wise to decide to limit the scope of the knowledge and the IP brought to the new research project. Of course, you cannot limit to zero. Say, I'm happy to enter the project, but I'm not going to tell anything about my technology. Of course, it doesn't work, but you can limit it in a way. The results, it was called foreground in FP7, now again, as it was in FP5. It's results again, of course, it's the new knowledge to generate in the project. Just very briefly, exploitation. Exploitation is not only commercial exploitation. So if in Horizon 2020 you have a rule that whenever you can exploit results, you have to exploit results, does not mean you have to exploit them commercially. Exploitation can also mean the use for further research. So I think this is important for many researchers in academic institutions. So they do not always have to become an entrepreneur. So they say, okay, but it's important that the knowledge is not left in the project. It should be used for further research and added value activities. So then the dissemination is simply the communication of results to the outside world, because it's a project financed by the European taxpayer. So what are the very general, very basic rules? If you participate in Horizon 2020 and you generate results, then you are the owner of the results. It's very simple. You means the legal institution you work for. It's not the scientist. And of course, there are many internal rules in different countries and different institutions, and this is up to the institution to set the internal rules. But of course, it's not that you work in a collaborative research, or it's not due to the fact that it's paid by the European Commission, that the knowledge belongs to the consortium. If you are the owner of the results, or if you are the creator of the results and the inventor, then you're also the owner. Of course, sometimes it might be wise that you have some proof of evidence, that you can prove that you are the inventor, like invention disclosure forms in the different institutions, or lab books and so on. And of course, we talk about joint ownership in many cases, because it's collaborative work, it's teamwork. And in many work packages, in many labs, you might invent together with other partners, with staff from other institutions involved in the project. And then of course you have to deal with joint ownership And you will find a couple of, let's say, fact sheets and frequently asked questions on the IP Helpdesk website also dealing with joint ownership agreements. So there is a default mechanism. So if you can, for example, you can draft a joint ownership agreement individually for your project, and I'm sure your tech transfer office has some examples of it, how to deal with joint ownership in collaborative project. If you do not manage it in a separate document, then there is a default mechanism in the consortium agreement, so that both inventors or both partners can keep on working with the results and it's not blocked. So that you can say, I can use it for my own purposes, I can even issue a non-exclusive licenses to others to the knowledge, providing a fair compensation to the partner involved. So there are some mechanisms which allow you to deal also with joint ownership without having a separate document signed on it. But of course, it is wise if you know there is a real value in the IP, and you would like, for example, not only to file a patent but also to use it for businesses. Then of course it might be wise to have a joint ownership agreement, which is ruling, for example, who is bearing the costs of filing a patent and how to share revenues, if there are some revenues later from that. And by the way, it is nice to file patents as a result of a Horizon 2020 project, but it's not a purpose per se. And we had discussion with the Commission last week because they make a study at the moment about patents filed in FP7, and I think 60% of the patents filed there were not maintained after the project finished. So you see, really, it's just to see that like a deliverable, to show to the Commission, we are very good, we are very successful, we filed a patent. But there was never a business strategy on it, and I think that's the purpose of that workshop today, also to say, think about business, not just filing a patent. It might be nice to file a patent, and for many businesses important to have it protected with a patent. But the idea behind is a strong business idea and a business approach. And this is what also in the proposal is asked. Not enough to say we have some experience in filing patents. I think it's nice, but I think that's not the question. The question is, do you have an idea how to exploit it? And then patents might be a good idea to start with. So what are the conditions under which you work in a Horizon 2020 project? Of course, for the implementation of the project, it's royalty free. You cannot charge your partners in the project for exchange of knowledge and exchange of information. But when it comes to the use of the results going beyond the project, then of course it's not the deal that, for example, industrial partners can rely on the fact that we've been partners in the FP Horizon 2020 project and now I get access to your knowledge on a free of charge basis. Then it's up to the partners involved to negotiate licensing agreements or transfer agreements, assignments on the basis of royalties.
Excuse me.
Yeah.
Hi, David Steinberg, I work for Swedish University. Why the open decision between royalty conditions in this case? Is there some sort of you seem to advocate the DESCA model before others you mentioned in passing. Could you briefly just perhaps explain the reasons in your words for that sort of
the conditions under which you provide access to the knowledge? I mean, for the project itself, it's clear. So it's free of charge. I mean, you apply as a team, and of course you are running the project as a team, and of course you do not charge for the exchange of knowledge in the consortium meeting. But when it comes to the exploitation or commercial use of the knowledge resulting from a Horizon 2020 project, then it is up to the partners to decide under which conditions they can do that. They can do it even free of charge, royalty free. If they say, I'm happy that I found a company ideas further and do not want, or the institution does not want to charge anything for that. But of course, it's not a must. And this is, for example, something which you can find in other, as you said, in other consortium agreement models. For later, it's on a royalty-free basis. So that means any academic institution participating in that project has to provide access to knowledge on a free of charge basis so that the industrial partners can exploit it commercially later. which could be an idea in the DESCA model, which could be an idea in the, but it's not a must. So it's free to the partners to decide on the conditions under which a company, for example, get access to patents or get access to knowledge created by an academic institution. So it's just leaving the floor to the discussions and not setting the scene in a way you have to do it on a free of charge basis. It's up to you to decide a business model.
Quick questions too. Do you have any sort of tables of license rates, or do you have any suggestions on how to think of license rates when setting them?
This is something we could not put on the website, of course not, but you could ask the helpline to ask for, because it's pretty much technology driven. So of course licensing shares, royalty shares are quite different in the pharmaceutical sector than in the engineering sector, and you could address to the helpline to get some insight on that.
Okay. I know there are
Because it's also, there's also, let's say, because we rely also on market figures we get from new publications and. Yeah.
I know there are books on this, but I just wonder what
Yeah.
one could reach it by.
But I would even say that the technology transfer offices in the institutions are quite aware of them, many of them at least. I would say that would be my first address. Yeah.
I just add something about licensing. There's the Licensing Executive Society, LES. Do you know about that?
Not really, no.
Licensing Executive Society. Actually, it's at European level, but each country has its own branch, so you can contact them. And they have also some schemes and way to calculate royalties based on technology fields.
So is there a time frame for how long you have access to the background IP from your consortium partners? Is there a time?
Yeah, it is. There is a time given in the grant agreement, and you can influence it also in the consortium agreement. Normally, it's up to 2 years.
Right.
Yeah. So it's good, but could be limited to 1 year. 1 year is the minimum. But it could, for example, in those templates which are driven by industry, it's up to 5 years. So up to 5 years after the completion of the project, you still have to give them access to your knowledge. But normally in the DESCA model, it's 1 or 2 years.
Just a question for when you give an answer to the fair rates, is IPRTS considered as a neutral partner to indicate for a neutral position?
No. No, you cannot rely on that position in negotiations. It's just an information.
Just
We
a-
cannot take a position there, yeah. It's just to help you to get access to information
But
which
it
is
could help
which is
if
available.
there is difficult negotiation
Yeah.
to ask you as a
Yeah.
neutral.
Not for this case, not for licensing. I mean, for the consortium agreement, yes.
Yes.
You can. We got a number of, let's say, consortium agreement being in preparation, and there are some specific clauses in it. For example, a big issue is that if you work with companies and they have headquarters outside Europe, and they place some specific rules on it on IP, because they know about that in their country, and then we can take a position on the way, is this compatible with with the rules for participation in Horizon 2020? So, okay, sorry, you cannot accept this because it's not in line with the rules for participation.
I wanted just to follow up to your question about the choice of between royalty-free and fair and reasonable conditions, and also following on what Jörg was saying, this much depends, in my opinion, also on the commercial considerations that you should take into account within the plans for exploitation and the dissemination of the research results. So, saying that if already at the outset you have a clear idea of what you are going to develop at that time, and you see the commercial value of the results, at that time you can decide whether to put it on fair, reasonable condition or on a free base. At the same time, you need to take into account the collaboration with your partner. There are also consideration of technology exchange between you and your partners within the project, because it might be possible that you develop something and you want your partner access it under fair reasonable condition, but at the same time you may need to have access to your partner's technology. So at that time this kind of consideration.
No, my point was merely that it looks fairly simple when given a choice, royalty-free or reasonable, but actually the background as to how to make that decision is much more complex. And
Of course.
taking into account state aid rules, taking into account what you're actually licensing, the actual value, etc. So that is just, if you have some sort of brief comment on that. Because it's usually, if you rely on the desk model negotiations, you end up with that having that discussion. So I was just curious if you had it.
At least you should have a certain flexibility and freedom to operate in a way that you are not bound by very strict, let's say, regulation as it is in some of the templates. Would you like to take on for the dissemination part?
Oh, right, yeah. Do I need a microphone or I can carry on? No, but just because it's just 3 minutes. Do you have a microphone?
If you could just.
It's for the finish.
Yeah.
Maybe we can do it. I
guess you
Okay, just. All right. So just to introduce a bit the dissemination issue, because well, I'd like to speak about the open access basically, but since open access is within the dissemination obligation, so I will step in at this moment and carry on by saying that, okay, project partners and beneficiaries of your funded project need to disseminate their results swiftly, so, and their first convenience. Before doing that, of course, before any dissemination activities take place, two main considerations need to be taken into account. Firstly, no dissemination activity is possible before any decision has been taken about registering and protecting intellectual property rights, because any dissemination activities may hamper or hinder the possibility to patent technologies, what is called disclosure. So, and also because of this main point and this main reason, you have also to inform your project partners about any intention of disseminating project results, which is normally given in 45 days prior notice, with 30 days for your project partners to reply to put forward some concerns about the dissemination. In any case, and in practice, terms can be reduced at pleasure of project participants within the consortium agreement, because, as you know, we were talking with Jörg, in a practice, researchers and project participants do not need 45 days to prepare stuff for dissemination, posters or whatsoever. So the time can be reduced, taking into account the right, the possibility. You have to give the possibility to your partners, to your project partners, to reply, and then also to take into account the time to modify any publications that could hinder, in effect, the project results exploitation. So we can get to the open access issue, which is one of the major change. Well, not real change, because open access has been piloted under FP7, and given the success, let's say, the European Commission decided to make it mandatory for Horizon 2020 for the 7-year new framework program. Why obligatory and mandatory? Because it has been assessed as a very good means to foster innovation, to exchange, to give access to the results on a free basis, will allow, in effect, other people and the European, let's say, society, but more in general the society, to further develop on these results. So fostering innovation is at the base of open innovation, open access. When we use the word mandatory and obligation, there's an obligation only for publishing research results in journal articles. If you want to disseminate research results by other means, you are not obliged to do it. I mean, to put it under open access. So the obligation is just when researcher wants to publish it under the form of scientific articles. This is the main issue to be understood, because only in this way you have this mandate to put it under open access. We have, well, basically, as all dissemination activities, the decision to put it on open access comes only after the decision of protecting intellectual property. Again, because otherwise the results cannot be exploited. Once you decide to publish it as a scientific article, so open access can be under the green open access or the gold open access. The green open access is when the publisher put the article at disposal of the users within an embargo period, which is normally 6 months for all the publication and 12 months just for the societal challenges. Why the embargo period? Because in this case, in effect, the cost to publish in open access can be recovered by the publisher. Right. On the other hand, open access allow, in effect, the users to have access to the research results immediately upon publication without any embargo, and the costs are supported by the publishing authority. Sometimes this authority can be also the European Commission, meaning that these costs are eligible for reimbursement and the eligible costs, of course, and during the period of the project, the Horizon 2020 project. Besides that, there's also a pilot program to try to reimburse this cost after the project. Now, what I'm telling to you, I'm finished, everything is written within the fact sheet that we've published and we've developed in collaboration with DG Research, the Open Access department of DG Research, that should be read in parallel with the guidelines on open access, in which you will find all the information needed, for example, about this piloted program, because together with information about research results, you should also provide the data underlying your research results. But in that case, there's no obligation. You might choose to opt in or out. But again, everything is better explained within this fact sheet and within the guidelines. You will have also within the fact sheet the email address of the Open Access Department of the European Commission, to which you can address all the concerns about open access. Thank you.
Is there a central register for all open access, or is it just is there somewhere you go on the Horizon 2020 to see all the results that have been disseminated through open access? Is there one
Horizon
place
2020.
when you go straight to the portal, will that tell you all the projects that have provided open access?
Well, actually, there's a sort of repository,
Right.
where you can find all the research results accessible under open access,
Through the
which is not,
Horizon
yeah,
2020.
yeah.
A question on the embargo that you mentioned. You mentioned 6 months for scientific publications
Yeah.
and 12 months for civil.
The green one.
Yes. Now, is this deadline sort of a mandatory limit within set by the EU?
Yes.
So you have to make it available after 6 months. And how can we be sure that the publisher actually agrees to that?
Yeah.
Is that, if not, it kind of limits, it limits our choices in terms of where to publish, which might have some impact on the prestigiousness, credibility of the journal, because there are issues with open access. Whereby
And this is one major issue.
Yeah.
One major concern. Actually, speaking with the officer in charge, he told me that a lot of publishers are more than willing, partly, to publish after this embargo period, But most importantly, and I forgot to tell you that, there's the hybrid publishing model, which is you can publish within very good scientific journal, which allow access only to your article on a free basis. You see what I mean? So articles that are that need to be, under fees, to be accessed under fees, but that allow to access only your articles on a free basis. This is the hybrid. This is the hybrid solution that can be proposed to the publisher, for example.
So basically, we're supposed, as researchers, as scientists who publish, to negotiate with the publisher the right to freely distribute our paper or manuscript work after this 6-month embargo.
Yeah.
Okay.
Probably it's a very simple question. So once an article appears in open access, it's open. So after that, it cannot be protected for IPR. Is that it? Or, for example, if it appears on an open access conference journal, whatever, it cannot be filed for patent, can it? Because
that's the main problem.
Right.
That's why you really need to take decision before.
The reason why I ask is because in certain countries, for example in America, even if the article appears in a journal, we have about a year.
Yeah, but that's a different system. They got this grace period.
Precisely.
Yeah, they got this grace period which doesn't exist in Europe. So at the moment in Europe, you say something in front of one person, you disclose your idea. Please.
For the green route, do you have to pay the publisher, or is it only the gold route where you have to pay the publisher?
No, the green, there can be some expenses. For example, to process the article electronically, process the article, right? And this cost can be reimbursed under the Horizon 2020.
How much?
Of course, the gold one, it's more expensive because there's no embargo period. That's the point.
Right. Do you know the average kind of price for the green route?
No.
Because I've heard that some are around €2,000 for the gold route. So I don't know what the green route average is.
No, I'm not expensive about these costs, but normally, as long as they are fair costs, they are reimbursed. This is what has been. In fact, this is one of the questions. Because the fact sheet is under the form of FAQ. So up to which ceiling the European Commission is willing to reimburse, there's no ceiling, basically. But if it's fair, what is applied here is the basic principle of all the costs eligible under Horizon 2020.
But for the budgeting, the proposal, for example, it differs a lot, the technology subject, of course. But what I know from some of the technology areas, what they do is about 500.
One final thing about budgeting. Thank you very much, Jörg. When we talk about gold open access mainly, which is the most expensive, we should consider including these costs within the proposal, so within the budget foreseen in the proposal. This is very important. Thank you very much. Okay, thank you.
as we are running out of time and Eugene Sweeney is already in pole position here in Formula One. I would like to bridge the gap also to the, let's say, to what comes next. We develop strategies to exploit the results, and just to finish with some of the obligations we have. So if there is a chance to protect the results and the findings of an FP7 project, then you have to do it. But of course, it is always under, let's say, provision that it is reasonably that those results might become of interest for commercial or industrial exploitation. So it's always up to you to decide whether really a protection makes sense or not. It's not just to say, in any case, I have to go for a patent. It's not the case. And if you talk about protection, it's not only about patents. So any kind of IP, registered, non-registered, any kind of IP is valuable, and of course it could be part of your business strategy. And sometimes it might be even more valuable to go for a trade secret or to use trademarks as a kind of a business tool. So it's important that you show maybe in your proposal that you understood that IP is not something to be left for the legal experts, but it's a business tool. IP is a business tool. It could open you business opportunity, and you can even charge costs. We come to that also for specific, let's say, IP consultancy, or to address to a legal professional, for example, to look for protection of specific software is important for further exploitation as a part of your business strategy and part of your proposal in Horizon 2020. You see here, this is of course always related to the justification coming from what you're doing in the project. But on the other hand, if you say we are going to have, let's say, develop a specific open source contract or doing some specific IP considerations when it comes to software exploitation, that might be also good to have some costs budgeted for IP expert in that field. And the same for open access, as mentioned before. So there is an application to protect, and there is an application to exploit, if it is adequate. But again, here, exploitation also means to use them in further research. It's not only commercial activity. If you see a chance that findings, results from your project might fit into other research activities in your institution or you're aware of, that might be important to mention them and to see how you make use of that knowledge in order to stimulate and create added value for research activities outside your project, and so on. And there is no, let's say, there's nothing given about how you should exploit it. It's up to your creativity and, of course, the circumstances, the considerations for your project, what might be a valuable opportunity to exploit results of your project. And this is exactly the core of the next presentations. So that how to think about potential routes for exploitation, like starting a spin-off activity, or creating joint ventures, or licensing agreements, or assignments. And of course, standardization is a big issue in Horizon 2020 when it comes, for example, to specific areas in engineering or in mobile communication and so on. So you see here, there is a wide range of opportunities, of potential channels for exploitation, and that's the purpose of the training, to see from the experiences of the trainers whether you might get inspired to develop and to design an exploitation strategy for your Horizon 2020 project. So that's more or less the agenda of the training for today and tomorrow, is that we start a little bit to understand the scene, what are the terms, the rules to use IP in Horizon 2020, what can be negotiated, and then to see, okay, what are the questions you have to raise in order to develop a strategy. For some, it's important to know about what are the interests and the motivations of your partners in the consortium. Because it's important that your project shows that there is not, let's say, a bunch of individual IP strategies coming from each individual partner, but you have a coherent an overall IP and innovation strategy, which is more than the individual ones of the partners. That you develop a common strategy and you use synergies and you use the different contributions from the partners to develop an overall strategy. And I think that's one of the messages which came across from the first evaluations. This is rarely seen in the proposals. So most of them explain what they are doing with the results. And there is nobody who is able to just to design the picture, the overall picture, the big picture, how to put together the expected results from the partners, in particular when it comes to develop systems, how to configure the different components of the partners into a running system. That's definitely a very tricky and a very challenging task, but this is something in many topics which is asked for. To develop strategies and plans to capture the knowledge and to manage and exploit it. And of course also to develop the management structures in the project, because innovation does not come just by itself, it has to be managed. So for example, if you deal with tricky IP issues, do you have an advisory board or an IP manager, which, for example, if there is a conflict, has a say on it and tries to moderate the situation, tries to find a solution on it. So those are questions, issues, which we are going to address now, in the next presentations. And please feel free to ask questions. Please feel free to provide feedback, and so that maybe at the end of the day you get some new ideas and also insight to develop a strategy which fits the best to your research. So thank you very much. So and we have a short coffee break outside. Thank you.